Hi, hi everybody. Yeah, so we're going to start by just kind of going over what an NDA is and how they're being misused in Canada. So the definition of a non-disclosure agreement is a legally enforceable contract that creates a confidential relationship between two parties. So one that holds some sort of information and one that the information will be disclosed to. So in essence, it's a legal obligation to compel privacy and to keep confidential information secured. So they began in the 1980s and they were common within technology companies. They were used to protect trade secrets, client lists, and designs. However, they have shifted to become very common in civil cases and just a standard in workplace termination cases, sexual abuse and harassment cases, and racial and gender discrimination cases. They are often used in large institutions for its members and students and employers, such as post-secondary, churches, the RCMP, military, but have been common among workplaces of all kinds. So today we will be focusing more on non-disclosure agreements within sexual violence cases and the impacts. So for people who have experienced sexual violence, they often feel coerced into signing a document without being given the information needed to make an informed decision. So an NDA can be viewed as a way of ending a potentially lengthy or strenuous court process for somebody who's experienced sexual violence. It may be viewed as a way of settling the case if there's compensation tied to it. So feeling that they're receiving something if they don't feel like their case will receive justice. They're viewed as a way to ensure their own confidentiality, but in turn, it also protects the person who perpetrated violence. And people are often unaware at the time that they're signing away their right to speak out about their experience. So they're given this NDA and they're pressured to sign it, but they're not really given the information about it. And they're often fear of repercussions of not signing an NDA. So if they're in a small industry and they are reliant on a reference or the reputation, there could be some fears of what will happen if they don't sign the NDA. So the misuse of NDAs in sexual violence cases, the person who experienced sexual violence to sign away their human right to speak out about their experience, how they want to, and to who. It impacts, sorry, is there, I feel like I keep getting alerts when people keep coming in. I don't know if there's a way to take me off host. Thanks, Kat. Sorry about that. It impacts the survivor's healing process by silencing them. So they're often unable to share or process their experience with the people closest to them. And also some NDAs will require support a professional or therapist to sign off on something before the person who experienced the violence even shares their experience with them. So it creates a lot of barriers. And it creates a culture of fear and silence within institutions where people can't speak up about sexual violence without fear of retaliation and having their membership, employment, or education held over their heads. So this silences conversations about sexual violence from happening. And it does protect the person who perpetrated violence. So they can go to a different workplace, for example, and they can repeat the same behavior, and the person who experienced the violence or witnesses who are under NDAs are not able to speak up about it if they want to and warn others. And they're become so common because they're within the institution's best interest to use them sometimes because it protects their own reputation. So they're often using it because their reputation and their rankings can go down if there's the knowledge about sexual violence and the reputation is widely known. So that's why we're seeing so many places use them. And for people who are in NDAs, they often remain in them because it's costly to challenge them. It requires financial resources and it requires knowledge about the legal system. And they're also at risk of being sued if they're broken. So because it is in the interest of institutions to keep using them, it is essential that there is legislation in place to prevent them from being misused. And currently there is collective actions taking place across Canada to prevent the misuse of NDAs. A lot of that work is being led by Julie Mcfarlane, who we have here today, and Zelda Perkins. And with the global Can't Buy My Silence campaign, which we're going to be talking a lot about during this presentation. But on May 17th of this year, PEI, which is our smallest province, will be the first province in Canada to significantly restrict the use of NDAs under the Non-Disclosure Agreements Act, which is Bill 118. This bill was passed unanimously in November 2021 and will limit the use of NDAs in discrimination, sexual violence, and harassment cases. And similar work is being done across the country right now to implement similar legislation. So that's happening in Manitoba, in BC, and right here in Nova Scotia, which we will be talking more about and how you can be a part of it. So right now, I'm going to invite Kristina to introduce our next speaker, Dooley. Thank you.
Thank you, Sarah, for that. So our next presenter is Julie Mcfarlane. I just want to say a huge thank you for the amount of work Julie has been doing with Zelda and her team with Can't Buy My Silence, and how you've been helping me with the work here in Nova Scotia and what needs to be done, and for being here today and sharing your knowledge around this and all of those pieces. So just a huge thank you. So I also want to encourage individuals to, if you haven't already done so, getting Julie's book. It's called Going Public, A Survivor's Journey to Grief to Action. And really taking a read of that and looking what's in there and how there's so much good information in there and so important for survivors and individuals who are doing advocacy, whatever role you're playing in this, so important. So I'm going to hand it off now to Julie to share some information.
Thank you very much, Kristina. Really appreciate it. It's great to be here today. Great to be in the company of people who are so committed to this work and do such important work to support people. But I'm so impressed by the fact that you're also paying attention to the systemic issues as part of your work, as well as working with people as individuals, which is fantastic. So I'm, first of all, just want to kind of locate myself so people sort of know where I'm coming from. As I describe in my book, Going Public, that Kristina just mentioned, I'm a survivor of sexual violence. I actually went public with that in Sexual Assault Awareness Week, which I think actually in those days was just a day. Now it's a week, which is, or even a month. Is it a month now? I think it's a month. So the students at my law school in 2014 organized an event, and I decided I'd take the opportunity to do something I thought about doing for a really long time, which was to kind of use the platform that I had to be, you know, someone who would stand up and say, you know, this happened to me too. And I was, that was a very important moment. And obviously a lot of things have changed in my life since then. And the book describes what ended up being a civil lawsuit and a criminal prosecution of one of the people who abused me, and just how incredibly difficult and painful that was, even for a law professor. Yes, it was really, really a very difficult and painful, but very important experience. So the book describes that, and also how I stumbled into NDAs, which I'll say a little bit more about in a moment. But that's who I am. That's where I'm coming from. Myself and Zelda Perkins, who was the first woman to break her Harvey Weinstein NDA. We met online, as of course all the best relationships start these days, at the beginning of 2021. And Zelda had already been working on trying to bring legislation forward in the UK for some time, but it had basically gone south because a certain Boris Johnson had become Prime Minister, who was not nearly as interested in this subject, presumably because he has many, many NDAs in his own closet, as the previous Prime Minister, Theresa May. So Zelda was kind of trying to figure out what next. And so we put together this campaign, which started in the fall of last year, that is really going very directly for legislative change as a way to fix this. We are also working on some sort of voluntary interim pledges from universities and other organizations, but our goal is legislation, and I'm happy to say some more about that a little bit later on as well. Now, Sarah's done a great job already of giving you a bit of a sort of overview, and I don't really want to be too repetitive, and I'm a bit afraid some of this might be a little repetitive, but on the other hand, there's a lot about NDAs that I think gets very confusing, and I would say almost intentionally confused by the people who use them, by lawyers. And so what I want to do is maybe just kind of really clarify for people so you can see how they're working to build on what Sarah said and where they come up all the time. And she was exactly right to say that these began in the 1980s to protect intellectual property, trade secrets. The campaign isn't aiming to change that. But what's happened is that they've crept into more and more and more areas now. And as I'm sure the people on this call know, are actually very, very common. So first thing is they're mutual. In other words, that the victims have to promise their silence in order to secure a settlement that protects their own privacy. And I think this is one of the really important things to first of all, really understand, because it's often said erroneously that either victims want NDAs, well, they don't want NDAs. What victims want is their own confidentiality, one-sided confidentiality. But this supposed bargain they're making in an NDA means they can only get their confidentiality if they give it to the other side as well, which of course creates an enormous problem because it's covering up wrongdoing. And I think that sometimes the impression is given by lawyers that this is the only way that confidentiality can ever be attained by a victim. And that is absolutely not true. It is possible to have a one-sided obligation in any kind of an agreement. If you and I are having a dispute and we agree to settle it by each of us, getting a gift for the other, they don't have to be the same gift. This is a real myth that somehow a victim can only have privacy if she gives it to the other side. Obviously, a one-sided confidentiality clause to protect the victim is going to be harder work to negotiate, but it's perfectly possible. So if anybody tries to say, oh, no, you can only have confidentiality if you give it to the other side, absolutely not true. This is a widely popularized myth that I think confuses people. NDAs are permanent. And that's a hugely important part of this because, we do customarily go into some kinds of legal processes, such as mediation, agreeing to keep the process confidential as long as it lasts. And the idea of that, and I'm speaking as someone who was an employment mediator for 25 years, is you have this kind of cone of silence that just helps people to feel at liberty to speak freely. It's a without prejudice discussion. But what's really important to understand is that's over once the mediation's over, whereas NDAs are forever. And what I've seen as a mediator is increasingly mediators start using clauses that aren't just about confidentiality and the protection of the admissibility of the information for the mediation, but they're actually forever. I have even seen a couple of NDAs now in which the obligation to be confidential is said to bind that person's successors. I mean, this is completely bonkers and almost certainly unenforceable, because what somebody is doing is saying, not only will I never speak about this, but neither will my successors. I mean, this is insane, right? And there was a clause like that in the infamous Virginia Go-Free contract with Jeffrey Epstein, which they tried to use then to protect Prince Andrew. But of course, a clause that says that my successors are never going to sue, totally unenforceable and ridiculous, but that gives you an idea of just how far these are being tried on now. As Sarah's already said, confidentiality is required in an NDA to all third parties. And sometimes, I've seen NDAs that specify, including family, friends, and relatives. Even if it doesn't specify that, people who sign NDAs inevitably, understandably, tend to operate on the worst case scenario because they're terrified of breaching. And so they will interpret, even if it's not specified as being even their closest family members, even a professional therapist, there is pretty much an assumption about that people carry around with them. And that relates, of course, to the trauma that this which we're going to talk more about. Breaking the NDA technically means breach of contract, technically. And that's what's being held over people's heads, of course, to comply. In actual fact, we're seeing more and more decisions at the moment. These are in the US. We've just started to see a couple in Canada that are looking at the clauses of NDAs and saying, this is too vague, this is too broad, this is not enforceable. And I think, if we were prepared to wait for the case law to catch up, then maybe in 5 years' time or a bit more, we would have enough cases that people could feel some confidence that they are not legally bound by these documents they've signed, and they could go ahead and break them. But to me, that approach, the case law approach, is too slow. It still puts all the pressure on the victims to take risks around breach. And so that's the reason why we're going for legislation, legislation that will simply make NDAs unenforceable. Unless they meet extremely stringent conditions, such as the ones set out in the PEI bill and now also in the Nova Scotia, also in the Manitoba bill. This is based on a bill I originally wrote for Ireland with the staff of the senator there who's putting this through in Ireland. And these are conditions that are basically impossible to fulfill. They include, it must be fully understood, almost never fully understood. It must be done without duress. People describe duress all the time, of course, to sign these. And maybe most important of all, the NDA in the legislation will not be enforceable if it harms, if it harms or affects the safety of a third party. In other words, all those other people who now don't know about this perpetrator because it's been hidden. Or the public interest. And I don't know a single NDA in this area in relation to covering up sexual violence and sexual misconduct that could possibly pass that test. So that's the way the legislation is structured. So I think it's also important that people understand that there's kind of two ways in which this plays out. And I'm sure people on this call will have seen this. The most straightforward way that we're most familiar with is to silence victims, to ensure, as Sarah said, that those victims don't speak out about what happened to them, what they went through in order to bring this complaint, the facts of what went on, and of course, the identity of the perpetrator. So that's their most common usage. But there's another really important usage that I also want to highlight, which is that they're also made without victims being present, between employers and the employee or the perpetrator. And we see this a lot where somebody is being terminated for misconduct in a workplace, but there is this bargain that happens between the employer and the employee and the perpetrator to cover that up. And they make a monetary settlement, and there has become an expectation from the employee that this would include an NDA. So if you talk to anybody who represents the person being terminated in these circumstances, they will tell you, absolutely, I expect an NDA. And that's the expectation that has to change. If you think about why this is happening, it's because there's an almost perfect alignment of interests here. Obviously, the perpetrator does not want their identity or what they did divulged. They want to move ahead with their career. And in these cases, of course, they are enabled to do so. But the employer also has an interest in covering this up. Well, why would the employer have an interest in covering this up? The answer is a very obvious one, which is most complaints that come out of workplace behavior around sexual misconduct have been going on for years. This isn't the first time this person has been complained about. This isn't the first time that there has been, notice has been taken that there is inappropriate behavior. But because it's gone on for years and years and years and taken a long time to finally get to the point that the employer is prepared to do something and to terminate, well, by that point, the employer, if they're public about this, will have to admit that, yes, it did take them 5 years, 8 years, 10 years to get around to fixing this. And no employer wants to look like that. I often say if employers were responding appropriately and immediately to allegations of sexual harassment and sexual misconduct in the workplace, then they could stand tall if they then investigated and terminated. But because this has gone on for so long and there's so much history, they don't want that coming out in public either. So that the employer and the employee are basically complicit in this bargain. Pass the trash is the expression that's used widely. It's a kind of vulgar and unpleasant expression, but I tend to think it's a really good one. Basically, it means what it says. This expression actually developed originally in schools because there is so much passing around of abusive teachers that it got its own phrase, pass the trash. We associate it, I think, mostly with churches. My lawsuit was against the Anglican Church, and they certainly have been and continue to move the trash all over the place. Also the Catholic Church, also other churches. But we're seeing this as well in schools, in universities, in hospitals, believe it or not. There are cases involving misconduct by doctors, and they are simply being moved on to another place. And obviously in a whole variety of other workplaces. So that's the effect, is the pass the trash. And the victims are rarely involved. So, I think it's important to have on your radar, this isn't just a bargain with the victim. It's also often a bargain which completely excludes the victim and just protects the employer and the employee. Might be useful also just to point out that NDAs are used at a lot of different moments. Originally they were used in tech companies to hire people because they were going to be subject to a lot of confidential business information, which in the 1980s was becoming very valuable as tech innovations took off. We now, I think, mostly associate NDAs with the final resolution, the third of my boxes here. But I think it's worth pointing out that they do happen at other points in this process as well. I've already mentioned the first one, which is preemptively before a mediation takes place or an investigation. I am aware of many, many cases. And by the way, we have now, I think, 60 testimonies up on our website, anonymous testimonies that you can go and look at if you would like to read them. And people describe being NDA'd at the beginning of a process as well. This is especially common in universities. It also happens, however, in many tribunals, including human rights tribunals, where the parties are offered mediation at an early stage. In those cases, they are very often also signing something that is effectively an NDA. It's not just a confidential for the process, it's the whole 9 yards. And then the other time, less common, but I think it's worth mentioning, that people are being asked to sign NDAs is if there's been an investigation. If in your workplace you've brought forward a complaint about sexual harassment or some other kind of sexual misconduct, and there is an investigation, there is no straightforward entitlement, although health and safety lawyers might argue otherwise, but they haven't been successful with doing this yet. There is no entitlement for a complainant to access the decision. And I'm aware of many cases where in order to get the full decision on what that investigation found, not just the outcome, but the decision, people are being asked to sign NDAs in order to see the outcome in their own complaint, I mean, the full decision in their own complaint, which again, if you think about it, is kind of bonkers. So those are places that you might see them, and you may have other places that you're seeing them, but those are the three places that we're mostly seeing them. How pervasive are they? Well, important to know that 95% of cases settle. And that's always been the case for about 35 years now. Consistently, cases settle for reasons that I'm sure are fairly obvious. Victims want closure. They don't necessarily have the resources or the emotional stamina to go through what a full tribunal or court procedure would involve. So 95% of cases settle, and that's not in itself a bad thing, unless you get an exploitative agreement, which an NDA would be. And the other part to add on to this is that a number of lawyers now who work in this area estimate that 90% of those settlement agreements now include NDAs. And we're talking here not just about sexual misconduct, we're talking about all kinds of things: racial discrimination, harassment and bullying, fraud, consumer liability. If you buy a house in Ontario and you have a complaint against the builder, you go to a tribunal, through a tribunal process here, in which you will sign an NDA if you settle. So you can't tell anybody else about how that was a bad builder. You can't warn anyone else off. Now, a building is one thing, and then a person's integrity of person is another, but these are all ways in which NDAs are creeping in to civil settlements very, very pervasively. There are now studies estimating that 1/3 of all workers in the US have signed an NDA. Some of those are going to be still NDAs that relate to trade secrets. Unfortunately, we haven't got data yet that breaks that down, but a lot of them are going to be people who've signed NDAs as a result of bringing a complaint. Every sector, I've already said that, although we are starting, unsurprisingly, probably to see data that suggests that in the hospitality sector, these are especially rife. So, it's important not just to associate these with, Hollywood stars. We're talking about the young woman who works at the 7-Eleven, who's sexually harassed by her boss, or at Walmart or some other store for a minimum wage job. And when she has the courage to complain, the next thing that happens is she has a severance agreement of a pitiful amount of money. Many, many, many NDAs are attached to pitifully small settlements financially, and she has an NDA. And of course, one of the things that the NDA does is it means that you can't tell a new employer why you left your old job. This is something else that's being taken care of in the legislation, because that's ridiculous, that you can't even reveal that you left your last job, not because you just felt like a holiday, but because you were being sexually harassed. Sadly, these are still being used extensively in unionized workplaces with the support of union representatives. And I believe that this is a matter of education and really, encouraging unions to step up. And I have been a lifelong union member and supporter. But on this, unions do have quite a long way to step up to. They are, in any case, often not the best place to bring a sexual harassment complaint. A new report came out just a few weeks ago in Canada from the Canadian Labour Congress, which shows that if you compare people in unionized and non-unionized workplaces, more people will complain in non-unionized workplaces about sexual harassment than will complain about it in unionized workplaces. I mean, that figure is an incredible indictment, I think, of how much more unions have to understand what these issues are and understand that NDAs are bad for their members and they should not be signing them. In my case, that involved the University of Windsor giving an NDA to a tenured professor whom they terminated for years of harassment. He was represented by the union, of which I'm a member, obviously, and they signed the NDA. Interestingly, the president of the union had the courage later to realize that it was a terrible thing to have done, because we passed him then to all these other places. And I spoke up about that and got sued for defamation. So, I think that there is lots of space for unions to reflect and reconsider what they're doing in this area, but we certainly need change there. And I'm very encouraged that in Nova Scotia, the Government Employees Union has already said they will support this change. But I can tell you that's the only union so far in the country where I have had an explicit expression of support for this legislation and stopping using NDAs. And just in terms of another data source, we have a data partner in the UK called Speak Out Revolution, who do work on abuse, bullying, and harassment, not just sexual harassment, but more generally. And they now have data from their current survey, which is still there. You can go and complete it if you'd like to. It's on our website. They have 700 respondents now, very nearly, which is a very respectable number. And they have a question on NDAs, which we asked them to add, and it says, have you signed an NDA? ? And the answers are yes, no, and can't say for legal reasons. And of course, the people who tick can't say for legal reasons have signed an NDA. That's the whole point of the question. And that number is now at 37%, which is pretty shocking, I think. Practical consequences, Sarah has already talked about lots of these, but they permanently gag victims. They allow someone to stay put in their job or to move somewhere else with impunity. They protect the employer's reputation at the expense of the victim and future victims, of course. They chill the climate for reporting. The other data piece that we're just beginning to get some data on is how many people don't report sexual harassment or other forms of harassment because they anticipate being asked to sign an NDA and they don't want to. And we're just starting to get some data on that now. There's also some data on that in the Canadian Labour Congress report that I mentioned earlier. Clearly, people are not reporting because it's a huge disincentive to imagine that you're going to be gagged. And people talk, and they know that's going to be a possibility, and so it will greatly discourage them from coming forward. I've already said they prevent a victim explaining why they left that job. And as Sarah mentioned, they do also require co-workers such as I didn't sign the NDA at the University of Windsor, to either dissemble or tell lies. I got called by a number of law schools asking me why my former colleague had left. And this was when the penny dropped and I realized they'd given him an NDA. I have that NDA now, as well as his letter of termination and the letter of recommendation that the University of Windsor gave him to take to his future prospective employers. And I can tell you, if you put the letter of termination from the university and the letter of recommendation from the university, both dated the same day, side by side, you do wonder what kind of a parallel universe you're living in, as I'm sure you could imagine. And I was sued because nobody else was prepared to tell the truth, even though all my colleagues knew. This was totally an open secret that this person was a serial predator. And so I alone told the truth to the people who called me, and I was then sued for defamation in Trinidad, which is a defamation tourism destination, successfully. So I have a defamation order against me. And I still get letters from Trinidad telling me I'm in contempt of court, because of course I am, and that I'm going to be imprisoned. But so far, no one's come to drag me away. And then finally, and this is where I really want to be able to hand off to Kristina, as somebody, obviously with a lot more depth of understanding in this area. But Maya Angelou says it, as she always does, just right. There is no greater agony than bearing an untold story inside you. And the stories that we have collected on our testimonies page for the campaign, show this so clearly. One of the things that I often hear lawyers saying who represent victims is, oh, well, NDAs are so important for closure for them. Well, they have the opposite effect to closure, because even though when the lawyer finishes the case and settles it and, you know, everything gets tied up with a bow, it looks fine, it's usually 6 months, a year, even 5 years later that people start to realize, well, first they go back and actually read the agreement, which in the emotional trauma of getting it, they may not have fully, they usually don't fully understand, and realizing that they've been gagged. And, you know, the impact of that on people, I mean, there are so many eloquent stories on the testimonies page in our website, can'tbuymysilence.com. You can read them for yourselves, but it's a huge trauma that people carry on. And of course, it means that they can't start to heal because they feel like there's a sort of Damocles hanging over their head. And at some point, you know, if they breach, they might be taken back to court, as people have been in the past. So obviously, this means that people like me with chronic PTSD can't seek support. They can't even talk to those nearest and dearest to them and try to manage that. And the fact that they are constantly aware that they're living in this kind of constrained way is going to trigger PTSD over and over and over again. There's also often an element here of institutional betrayal, because the workplace or the university or whatever the context is, maybe it's a club that the abuse took place in, they're going to usually see that institution effectively siding with the perpetrator. This is what we see over and over again. And many, many women say that it's the institutional element of the betrayal of an organization or an institution that has been a really important part of their lives. I mean, think about the church, right? Being an important part of their lives no longer is the institution they thought that it was. You know, for myself, I worked in universities for 40 years. I believed in universities. I no longer believe in universities. I want them to be better. I haven't given up, but the betrayal is profound, and people describe it as profound as the abuse in some cases in terms of its traumatic impact. I've said this, obviously very difficult to get closure when you're living under the sort of Damocles that you have to be constantly afraid of breaking this NDA. And the sanctions, you know, are clearly set out in many NDAs. I've seen NDAs with penalty clauses of how much money each breach will cost. I mean, whether or not that's enforceable, it's terrifying to people to see that. In student NDAs, the usual sanction is expulsion. I mean, these are absolutely, you know, horrifying sanctions that are being threatened, whether they're enforceable or not. And something else that I see happens with people who've signed NDAs is, you know, they have to take care of themselves first and foremost, but many, many people who've experienced sexual violence feel, of course, very strongly that they don't want other people to go through what they went through. And I talk to people all the time. And again, you can see this in some of the testimonies, but I speak to people all the time who talk about, in addition to their own being gagged, they also end up feeling guilty about other people because they can't do all the usual things that we would do to warn somebody, you know, as we do in our informal networking, you know, don't go in the storeroom with so-and-so, whatever it might be. That's always been a natural part of, unfortunately, the way that women have had to take care of themselves. And now they can't even do that. So I'm going to, as I say, leave it at that in terms of talking about the emotional consequences, because I know Kristina has more to say, but I didn't want to end without just making that final point.
Thank you so much. And I'm going to hand it off now to Dee Dooley to speak. Dee is a community educator and gender-based violence prevention advocate and my former co-worker, colleague, and excited to have Dee here. So I'm going to hand it off to her now to speak a little bit.
Thank you, Kristina. And thank you, Sarah, for the overview, and Julie for highlighting some of those really important dynamics and outcomes and consequences of NDA. That was really important to listen to. So I'm going to share some slides as well just to go through. Hopefully you can all see that. So I'm just going to read a few quotes. Speak your mind even if your voice shakes. Eleanor Roosevelt. Oh, oops, technology. Once you start to speak, people will yell at you. They will interrupt you, put you down, and suggest it's personal. And the world won't end. And the speaking will get easier and easier. And you will find you have fallen in love with your own vision, which you may have never realized that you had. And at last you'll know with surpassing certainty that only one thing is more frightening than speaking your truth, and that is not speaking. Audre Lorde. The easiest way to disregard a woman's voice is to package her as a scold. Michelle Obama. The best way to cultivate fearlessness in our daughters and other young women is to lead by example. If they see women using their voice despite fear, they'll know it's possible. Gloria Steinem. It took me quite a long time to develop a voice, and now that I have it, I'm not going to be silent. Madeleine Albright. There is no force more powerful than a woman determined to rise. Bossa Sabelle. I've never been interested in being invisible or erased. Laverne Cox. So the movement to end gender-based violence began in community. It began with and for survivors. What started as whispers between trusted confidants and friends, as you mentioned, Julie, which is so important, led to the sharing of experiences and stories that were up until that time forcefully kept hidden through NDAs and violence and otherwise. Sent ripples through communities and ultimately around the world. And that is the basis for the programs, services, organizations, policies, legislations, and campaigns that we see today. The personal has always been political. The movement to end gender-based violence started with survivors using their voices. Speaking, using our voices comes in many forms. Survivors of gender-based violence have been using our voices and fighting injustice in the courtroom, in the classroom, in homes, and on the streets for decades, centuries even. Mobilization can take on many forms, from advocating for change in the legal process, as we're doing here today, to attending a bystander intervention workshop, to raising awareness by adding a hashtag to an online movement, to having a conversation with a loved one, to donating to a charity working on the front lines. Every survivor, every voice, every action matters. We all have a role to play in creating safe and empowering communities and supporting survivors in using their voices and being heard. Making space for survivors to share their stories and to use their voice is a vital responsibility of service providers, allies, supporters, and community members. We can also take care to uplift the experiences that are often not front and center. And I'd like to take this time to acknowledge that I am doing this work in Kjipuktuk, Mi'kmaq, which is the unceded and ancestral territory of the Mi'kmaq community, which I think is really important when recognizing the connections between settler colonialism, sexual violence, and the colonial nature of the legal system. We're all treaty people and have an active role to play in reconciliation, recognizing that the peace and friendship treaties that govern this land were first signed in 1752. So although Indigenous women, girls, and Two-Spirit people, Black women, women of color, disabled women, queer and trans women, poor women, and sex workers are disproportionately impacted by gender-based violence, these experiences are not often highlighted, not often front and center in our narrative. And this means that impacted communities must work twice as hard, extra hard, to have their voices heard. And every survivor's story and voice matters. Speaking our truths is a fundamental right, an important part of healing for many survivors of gender-based violence, harassment, and discrimination. Every survivor is on their own journey, and for many, advocating for change is a crucial part of their healing and can help to mitigate some of those impacts of trauma and institutional betrayal, sanctuary harm, and secondary victimization. So let us uplift the voices of survivors in our communities and create the conditions that allow them to speak freely, truth to power, and heal from their experiences. Thank you.
Thank you so much, Dee. So I'm going to get Kat to pull up. Okay. All right, so I'm Kristina. I'm a trauma therapist here at Avalon Sexual Assault Centre. I've been a part of some of the work that's happened here on April 7th with the press conference and the bill here in Nova Scotia, where Equity Watch, myself from Avalon, and we joined Claudia Chender from the NDP to get this bill moving forward here in Nova Scotia, and really following what was done in PEI. PEI has been really leading this work here in Canada as our smallest province. Just want to, like, as the smallest province, I think it's pretty remarkable how they've been leading this. So I just want to highlight that. So in regards to the window of tolerance, I think this is really important when we're talking about the impacts of non-disclosure agreements, and when we're talking about healing for individuals who've experienced trauma, and if it's harassment, if it's sexual assault, and really understanding when we're silencing individuals, when we're looking at their healing, what does this all look like? And when we're talking about institutional betrayal, when we're talking about secondary wounding, really looking at this diagram, looking at the window of tolerance and understanding what this might look like for a survivor who's been impacted. And as they, go through the process, which is highly re-traumatizing, through these settlement agreements, and then all the outcomes that come after that in their relationships, what they can share, what they can't share with individuals, how they interact with individuals in their life. So I just want people to look at this diagram, taking it in. So the window of tolerance is the zone of arousal in which a person is able to function most effectively. So you see that here in the middle. That's when a person is, emotionally regulated, has the ability to self-soothe and to regulate their emotional state. So that's ideal. That's where, we want individuals to be. That's the place that people are present and, things are going well. When we're looking at hyper or hypoarousal, and we're thinking about the use and misuse of NDAs for an individual who has experienced sexual violence. And thinking about where a person's going to be at, say, for instance, if they're tied into a non-disclosure agreement. And in their healing journey, part of that is wanting to advocate for themselves. Part of that is wanting to speak up. Part of that is wanting to speak to other survivors. Part of that is wanting to be part of change in what we're doing here today and what has been doing, what, Can't Buy My Silence has been doing. So we need to ask ourselves, where do you think survivors are at when they're tied into these non-disclosure agreements? What's happening in their life? And they're not often likely in this, in a window of tolerance. They're becoming triggered by lots of situations that are coming up, and this has long-term effects. So Ken, I'm going to get you to move to the next slide there. Okay. So the use of non-disclosure agreements is not keeping with a trauma-informed or a survivor-centered response to sexual violence. Non-disclosure agreements prevent survivors of sexual violence and harassment from moving on from their traumatic experiences while further being impacted by systemic abuse. The use of non-disclosure agreements contribute further to secondary wounding and institutional betrayal impacts. The misuse of non-disclosure agreements silence survivors, like we have all been sharing. And I think this is really, really important to when you're looking at the trauma-related impacts and a person's healing moving forward. And it impacts all parts of their life. Too often, non-disclosure agreements result in survivors finding themselves in constant fear of accidentally breaching the terms of their agreement and at risk of being sued. So again, referencing back to the window of tolerance, that constant fear, that constant interactions they're having, they're going on with their life, they're trying to, have relationships, keep relationships, exploring new relationships. Where do you think that an individual would be if they're constantly living in fear of breaching the terms of the agreement and the non-disclosure agreement that's in place? The harmful impacts intensify trauma-related symptoms, and they have long-term impacts on the body, the brain, and the mind. Survivors are left with distressing personal and professional outcomes of signing away their human rights to speak. And in my work with individuals who have been impacted by sexual violence and harassment, this process is silencing survivors and has long-lasting impacts after the settlement agreement is signed, and leaving individuals experiencing chronic hyperarousal or hypoarousal. And this is again directly also impacted by secondary wounding and institutional betrayal impacts. This impacts a survivor's it impacts their safety, it impacts their dignity, it impacts how they're able to trust individuals moving forward. And it also impacts how much control the individual feels they have over their own life moving forward. This results in survivors oftentimes being left feeling very isolated. And it has long-lasting impacts on their interpersonal relationships, their health, and can intensify chronic pain. And it continues to create an environment where their nervous system cannot maintain regulation at times. And when a nervous system is not able to maintain regulation, the impacts that has on an individual, on their health, and how they interact with their environment, how they engage with others, all has, a lot of consequences for an individual, for their health and wellness moving forward. A traumatized brain shuts down each time a person is triggered, every time they feel vulnerable and threatened. And trauma manifests in intense physical, perceptual, and emotional reactions to everyday life. And it's important because trauma does not just leave behind memories. Trauma impacts consist of symptoms and difficulties, most of which are unrecognized as trauma-related. And this is a disconnect, and trying to get individuals who don't have an understanding of trauma-related impacts to actually understand what that looks like can leave survivors also feeling very isolated in, engaging with our healthcare professionals who don't understand trauma and all interactions they have. So again, experiencing more secondary wounding when healthcare providers, service providers are, looking at the individual and not understanding how the individual has been impacted. And with non-disclosure agreements, and when a survivor cannot talk about those impacts, that puts additional wounding and harm and trauma-related, intensifying the trauma-related symptoms they're experiencing. Secondary wounding is a major cause of internalized shame, and it can result in the most damaging impacts with the potential lifelong consequences spreading throughout many or most areas of an individual's life. Those who experience sexual abuse are at risk of internalizing shame due to the humiliation of experiencing one of the most invasive forms of a human violation, and also combined where society questions and blames victims. We should be all very concerned about this, and that's why this conversation, the movement that's happening, and why we need to be bringing attention to this is so vitally important. In my work, the secondary wounding impacts in some situations have more devastating impacts than the original act of the sexual violence that occurred. The use of non-disclosure agreements leaves survivors repeatedly left feeling blamed, doubted, and re-victimized. And I just want everyone to sit for a moment, again, referencing back to that window of tolerance and where an individual is at, and if they're able to be in a place of regulation, right? In constantly feeling that shame, feeling like they're blamed by everyone who they're interacting with, doubted, because individuals are not understanding trauma, and also because they can't speak about the trauma and their stories. And I think that institutional betrayal, really, if we're looking at post-secondary education, universities, looking at institutions that carry a lot of power, when a person goes into a situation and they're dependent on that institution, and then the institution is not responding supportively to the wrongdoings by individuals that are committed within the institution, that harm and failure also creates a situation where the person, who has experienced the, if it's harassment or sexual violence that has occurred, they were not safe in the situation where that act happened. And then they're relying on safety to be coming from the institution or the places of work, the individuals that they think have the power to do the right thing to protect. And when the institution is not doing what is necessary to protect, when it's continuing to cause more harm, again, thinking back to the window of tolerance for a survivor. We have a responsibility to survivors, and we have a responsibility to change the response to sexual violence and harassment by eliminating the misuse of non-disclosure agreements. And this is just one area. In regards to, our responsibility to survivors, there's so many areas that this needs to be addressed, where we need to be having these conversations, and things need to be happening, within legislation. We need to be doing all sorts of things to be bringing awareness to this, to be talking about this, and having collective action happening on this. The use of non-disclosure agreements is deeply embedded in our culture and built into our hierarchical structures of institutions. And we need to stop protecting perpetrators at the expense of survivors. The misuse of non-disclosure agreements create a culture of silence, and this is unacceptable. We have a collective responsibility to protect, support, and provide safe spaces for survivors. For the individuals who are on the call today, if you're taking this back to, if this is, you're here as an advocate, if you're here as, someone working in another community-based organization, or you're an employer, whoever's on the call, I really want us to be critically reflecting about our role in this, what role you can play in this, what role you can play in moving this forward, what role you might have played in participating in this, in using these non-disclosure agreements, or witnessing it happening within your workplace, or you're on a board of directors and these are being used in the context of the organization or institution. Wherever you're at, whatever role you play, be critically reflecting on how these non-disclosure agreements are impacting individuals. There's a lot of work to be done. And around that, so on April 7th, here in Nova Scotia, like I said, Claudia Chender had from the NDP the bill has been presented, but that's only one piece of this and only one part of it. We need to get this moving forward here in the province, and there's a lot of work to be done in getting other MLAs on board with this, and our Minister of Justice on board with that. So there's going to be opportunities, and I'm encouraging everyone, you know, to look at what you've learned here today, continuing to learn about the misuse of non-disclosure agreements and how you can be involved in this. One thing that could be really helpful right now, because this is really current, that this just happened on April 7th, where this was presented, and you know, there's going to be work coming up over the next, you know, over the coming months here. We need to really get individuals, our MLAs. So we're going to provide in the chat, if Kat hasn't already done so, a list of our, you know, MLAs, and find out who your MLA is if you don't already know, and encouraging individuals to be making a call to your MLA's office and talking about non-disclosure agreements, how that you're urging your MLA to support the bill that has been put forth here, and that you're having conversations, right, and learning about this and finding ways and opportunities to bring this back to your workplaces, bringing this back to, if your organizations, again, wherever you're at, whatever way you can move this forward, getting informed, because we have a lot of work to be done here. And this is so vitally important for survivors, that we cannot rely on institutions, organizations to do the right thing here. And, you know, that can be very frustrating at times. We need this to change here at you know, we need to get this put in place with this bill, so that we're not running into these situations, leaving it to individuals to do the right thing. This is, you know, this situation is, you know, we need to be getting organizations, we need to be getting the right people at the table, having these conversations and supporting this. This is you know, the misuse of non-disclosure agreements is impacting women, our most vulnerable and marginalized individuals, our trans community. We need to be figuring out who needs to be a part of this, and how we're going to use our power, how we're going to collectively come together and move this forward around this issue and so many other issues that we need to be talking about, and we need to be finding strategic ways to be addressing these together. So like I said, call your MLA if you want to write letters, talking to the Minister of Justice. There's going to be opportunities, like I said, coming up here. Avalon is going to be a part of that. Also in working with Dooley, with Can't Buy My Silence. Again, I can't stress enough how much Dooley and Zelda have been really helping me here at Avalon with this work and what needs to be done here in the province. So please reference your MLA, getting this out there. We provided an example script for individuals if you want to use that, of course. Always encouraging people to get informed, finding ways to communicate whatever that looks like and what issues are important to you or what needs to be added to this. So we have the draft script there done up. And also, I just want to say that, you know, we have a collective responsibility with this. And, you know, I think that this issue is impacting so many individuals, and we don't even know about so many individuals who are impacted by this because they can't speak. And this is all so much more important as to why we need to be moving this forward here in the province. And we need to collectively be finding ways for opportunities to be working on these pieces together. So, you know, for community-based organizations who are part of this, for any individuals that, you know, are in advocacy roles, any individuals who might be on the call, that have any in leadership roles, if you're an MLA, how do we get this moving forward and how do we work together so we're not operating in silos, breaking down those silos that exist around these individuals and how we're bringing collective action together in moving this forward. I can't stress that enough. It's been so wonderful being able to use Can't Buy My Silence and all the work that's already been done on this to support the work that is necessary here in Nova Scotia and, everywhere, and all the other provinces that need to take the lead on this as well. So we also have the contact information for our intake to speak. If any individual, if you're a survivor of sexual violence and you're being impacted by a non-disclosure agreement, we have the contact information there. We also have the email. And if you're a community-based organization or, an individual that wants to get involved in ending the misuse of non-disclosure agreements, my email is there. Please reach out there. Like I said, there's going to be opportunities coming up to get involved in that, and it would be great. And I see Julie has also put Can't Buy My Silence information there as well, and it's so important. So please reach out if you have questions. Please reach out. We're here, and this is so important. I can't stress that enough, that we get this moving forward here, and we are better together in doing this, in moving this forward. So I want to thank everyone who presented, and I think we're going to stop the recording. And now